All right. Hello and welcome. My name is Mitchell Zadow. I'm the Managing Principal at Sharrock Pittman Legal, and thanks for joining us today for our webinar on warranties in contracts. Before we get started, we'd like to make a quick acknowledgement of the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and we extend this respect to all First Nations throughout Victoria and wherever you may be logging in from. So again, welcome. If you know, many of you have attended our webinars before, so if so, welcome back. And if it's your first time, then a very special welcome to you. And we just hope these webinars are a helpful resource for you to share, for us to share with you some of the must-know information that we think would be helpful for you in your businesses and other organisations. You can catch up with the recordings of these webinars on our website, and today's will be recorded as well and will be put up there. And you'll also see the webinars up there about other areas of law that our lawyers have presented on, including not only commercial law, but also property law, disputes, and wills and estates and not-for-profits. If you don't know much about Sharrock Pittman Legal, we do have several accredited specialist lawyers in some of these areas, which means we have a really good in-depth knowledge and expertise. But today we're going to look at something that comes up frequently in the commercial contract that we see, and that's warranties in contracts. So I'm joined today by Mehraaz, Sidhu from our commercial law team, and we work together in this area, and we're looking forward to sharing some pointers with you that you can use when you're dealing with contracts yourselves. Before we begin, I'll just deal with a couple of housekeeping items. As I said, we are recording the session and it will be on the website soon. And if you do have any questions throughout, please feel free to type into the Q&A box. We'll try to deal with questions when we have breaks throughout the session, and we'll have more time for questions at the end. We are conscious of your time, so if we do run out of time and we can't get to all the questions, don't worry, we'll get back to you afterwards. Now, speaking of wording and terms and conditions, we're lawyers after all, so a little bit of fine print. Needless to say, we can only really give some general guidance in this session. This is an area where the detail will very much differ depending on which side of the transaction you're on, whether you're the buyer or the seller or the service provider or the customer. So do keep that in mind. We're trying to cover all bases and all audiences today. If anything comes up in your own world that you need advice on or you're unsure about, do get some specific advice for your own situation. So without any further ado, we'll get started, and just a quick overview of what we're going to cover today. So we'll start off just explaining what we mean by warranties in contracts. It is slightly different to what you might typically think of when it comes to warranties. Then we'll go through some typical scenarios where we see warranties being used most frequently, and that's in the sale of shares in a company or perhaps units in a unit trust, and also in the sales of assets and goods. We'll have some tips on effective drafting of warranty clauses, and time permitting, we'll also want to cover what you can do if there's been a breach of a warranty. And then we'll finish with some questions. So first of all, what do we mean by warranties when it comes to contracts? We're not actually talking about warranties like you might expect if you're buying, I don't know, a coffee machine and it's got a 12-month warranty. They're what you might think of as consumer warranties and consumer guarantees. When it comes to contracts, warranties are really referring to promises or representations that one side makes to the other. And it's usually from the side of the buyer who's handing over money for something. They want some assurances from the seller about certain things to do with that company or that entity or the things that they're buying. So they usually relate to things like the truthfulness and accuracy of information that's been given to the buyer. So documents are correct, all the due diligence materials are complete, the buyer has received everything they ought to have been given and it's correct, basically. There might be assurances about the history of the organisation or the entity in a number of areas, and we will go into this in a bit more detail shortly. And there might be other things that are specific to that particular transaction. They are different usually from the main body of the contract. So clauses about payment and other obligations, a breach of some of those might lead to an ability to terminate the contract perhaps. But usually when we've got a breach of a warranty, that may not necessarily give rise to a right to terminate. Usually it would give rise to a right to damages. So some kind of compensation the buyer might be entitled to because they relied on those assurances. It turned out not to be true or accurate, and they've suffered some harm or damage as a result. So as we'll see later, so that might depend on the timing of when the breach is identified, before or after completion of the transaction. And as I mentioned before, this is an area where there's two sides to the coin. So for the seller or the vendor in a transaction, they will of course be wanting to have as few warranties as possible, and they'll want the warranties that are there to be limited as much as possible. And we'll have some examples of what that might look like. But on the other side of the coin, the buyer or the customer will want as many warranties as possible. They'll want to cover the ground as much as they can. They will want to have broad rights when it comes to enforceability of those and what they can do if something goes wrong. So you'll see in some of the examples we go through sort of tailored to one side or the other. So do keep that in mind. I think it's relevant even if you are more commonly on one side than the other. It's good to have a little bit of knowledge about what someone on the other side of the fence would be looking for when you're doing your contract negotiations. So I'll hand over now and introduce Mehraaz, who'll take us through some examples of the types of warranties that we'll see in some of these contracts.
Thank you, Mitchell, for setting up that background. What I'm going to do is essentially take you through three elements of warranties that are offered. I'm going to talk about the types of warranties that we generally see in a share sale agreement and an asset sale agreement. I'm going to talk about the purpose behind those warranties, why those are included, what's the thinking that a vendor may have, and what's the thinking that a buyer would have opposed to that, and generally touch upon common issues that we see sometimes that in negotiating warranties, etc. So talking first about the share sale contracts, obviously they are quite distinct from an asset sale, or when you're purchasing a business as a buying concern, where you may only be purchasing an asset of the business and the goodwill associated with it, but the entities remain separate. So there's a different corporate entity purchasing assets. In a share sale, however, you are buying into a particular company. So often with these sort of transactions, there can be skeletons in the closet, and it can be difficult to sort of ascertain what liabilities or what risks that you are buying into. And the only way to sort of get that done is by getting disclosures, proper disclosures from the vendor. Often it's considered that warranties, as Mitchell touched upon earlier, they have a dual purpose. One is preventative in terms of ensuring that there's a screening happening in the transaction. When warranties are offered, the vendor has to pay attention to the fact what is being disclosed, and when and it encourages the buyer to conduct that proper due diligence. And if they're breached, then there is that remedial purpose. So talking about that preventative and the screening purpose, really what we're looking for is, given that any purchase is going to be at the buyer's risk, the buyer wants to ensure that they've got as much information possible about the business as would be necessary for them to carry on with their activities. Now, warranties in a share sale agreement is distinct in one regard, and that is that often warranties are sought from the seller of the shares, the person who's holding the shares. It could be part sale of the shares. You may not be buying into the complete company, so there's going to be a certain aspect of the entity that is being purchased into, or the warranties can be sought from the company itself. That warranties would relate more about to the general operative nature of the business. If we can just go to the next slide. Now, in this slide, we've covered a few types of warranties that are generally offered in a share sale agreement. And you'll see that they're basically split into two categories. One of them are more fundamental warranties that relate to the actual shares that are being purchased, as we spoke earlier. And it can relate to legal capacity of the vendor to sell those shares. It depends on, they may hold the shares as a trustee for a trust. So you'd want to ensure that you're purchasing it from the correct entity. You'd want to ensure that the shares are, there are no encumbrances on it, and that you'll get free title to it. There may be information that may be required around the class of shares, etc. That relates to the corporate, somewhat to the corporate compliance element of it. And then there's the other aspect, which is the more operational aspect about the business, the value, revenue of the company itself that you're purchasing into. I'm just taking you through the points that we've mentioned in our slides. So the first relates to that information about corporate compliance. Now, you'd want to ensure that all ASIC requirements have been met. All shares are properly registered. They're on the register of shares. You'd want to ensure that in terms of operational aspect of it, that there are no outstanding liabilities, that there are no claims against the business or the goods or services that are offered in the business. And to an extent, we also see warranties where they're made on the basis that there are no threatened claims against the business or the shares that are being purchased either. So in that sense, there can be an expansion of the warranty that is being offered. And Mitchell will talk to you shortly about how drafting them, how the drafting of the warranties can be crucial in terms of ensuring that you're compliant with them. Moving on to, there can be also warranties related to statutory compliance and tax compliance, so that you're assured that at the time of your purchase, any sort of compliance from authorities, any notices, they have been all addressed. That once you buy into the business, and often with the share sale agreements, what we see is that a person would also have a right to either become a director at a later stage, or they would enter in as a director. And there are some liabilities that can flow on to the directors, such as PYG withholdings not being paid. So that this generally represents, the share sale agreement represents an opportunity to ensure that before you buy into the business, everything has been compliant and has been addressed. And if there's a breach of that warranty, and if the vendor has made a particular representation, that representation, if it's false, then you have a remedy available in relation to it. Some other examples include legal matters, as I talked about earlier, not involved in any sort of other criminal proceeding, arbitrations. Effectively, the aim is to get as much information as possible. So warranties are very closely tied to disclosures, and we've talked about how warranties are offered, how they're necessary for the buyer's protection. On the other hand, a vendor would also seek some warranties from the buyer. We'll touch upon this briefly, but in getting these warranties, often what we'll see is that a vendor will seek a clause that says that the buyer will not rely on any representations beyond what's given in the agreement. So again, getting to the point of connecting the dots, of ensuring that if a disclosure is made as a warranty, it should be accurate and assuring that you have not made any warranties about things that you may be unsure about, because then that creates a risk where a warranty has been given, but if that's breached, it can have significant consequences. And sort of touching on those consequences, one of that relates to the accounts of the business. Often you'll see that warranties are sought about the books giving an accurate financial position of the company, because the value of a particular purchase can be tied down to the current books of the business. So there are sometimes situations where a certain projection is given and a purchase price has been negotiated on that behalf, and often the projection is not met. So it becomes a question of, okay, what exactly did that warranty contain? Was it about the current financial position? Was it a projection? Similarly, you'd want to ensure that all the insurances are adequately in place. If a risk becomes evident and there is a breach and liability has to be paid off, then you're assured that the insurance will be able to cover it. So again, warranties become this mechanism of protection, and not just for the buyer, but as I talked about earlier, they become a mechanism for protection for the vendor as well, because they will want to ensure, vendors will want to ensure that they include warranties, and they can range from basic warranties such as ability to enter the contract, and not being in breach of any laws, to having warranties that notes that a buyer has conducted their own due diligence, that they're not relying on any representation not in the agreement. So in that sense, that agreement and warranties complete the transaction and lays out very clearly what the vendor is representing and what the buyer is relying upon. So that serves as a basis of ensuring that there is nothing sort of up in the air that goes beyond the terms of the contracts. And often warranties tie down with other provisions of the agreement as well, such as indemnities, the entire agreement clauses, and Mitchell would speak to you shortly, I believe, about those enforcement of warranties and how that drafting comes into play. One topic that I might touch upon, and I spoke about this earlier, was having good title to the shares. Now, often this is overlooked in a share sale agreement, and it's something that is examined in an asset sale agreement, are the PPSR registrations. People, sometimes there is this belief that shares cannot be encumbered, but as you're buying into the shares and not the actual assets, it's the assets that are encumbered. But if the shares are owned by an entity or a person, and PPSR registrations have been made against them or that entity, those shares can be encumbered as well. So it is important that those searches are properly undertaken, and there's proper due diligence to ensure that shares, when you do receive them, are encumbered and any PPSR registrations are removed. And if it's not possible to remove them because of any circumstances, exceptions should be noted. Exemptions should be noted within the contract, so that that vendor is protected. If you could just go to the next slide, please. Now, moving on to the warranties in an asset sale agreement, this obviously is a little different from the share sale agreement, but there is a lot of overlap between the warranties that are offered. One distinction is that you're generally not seeking warranties from the holder of shares, which can be different from the entity actually selling you the business, although you may be seeking some warranties from a guarantor in that asset sale agreement. Now, again, there's that basic sort of warranties around title and ownership. And as in contractual interpretation, there's a Latin maxim of caveat emptor, which essentially means let the buyer be aware. So without warranties, there's no recourse to any sort of for the buyer to say that um, uh, they were not aware of the business that they were buying. So it really becomes the buyer's responsibility to ensure that they've done their due diligence. And if there are any representations that they want to rely upon and they're specifically relying upon, they are included in that agreement. And this could be particularly important in an asset sale agreement because of the nature of the asset. It depends on the nature of the business that is being sold, the types of warranties that will be offered. But some of the usual ones are, as we've talked about earlier, the PPSR registration, making sure there's no encumbrances, ensuring that the assets are in good working order, the inventory and stock is in sellable condition. If there are particular um, rights or particular, if for instance, if there's an IP asset being purchased, you'd want to ensure that there's no third party rights that are being infringed. In certain businesses, for instance, if it's a telecommunication business or if it's a construction business, it's going to vary. The nature of the warranties sought in terms of the assets being sold will be varied. In a real estate business, for instance, if a rent roll is being sold, it is an asset of the business, but you'll be seeking warranties, for instance, to ensure that there's proper authorities in place. So dependent on the business, the warranties and the nature of those warranties would change, and it's important to examine that. We've seen situations where there can be licenses associated with the businesses, and permits associated that can't be transferred across, but there's still a necessary requirement for the license for the business to be sold or to be operated. So you'd want to be ensured that those licenses are not breached, and they're either capable of being assigned or there are mechanisms built in which allows a buyer to get a new license in place until that settlement is effected. Um, Again, similar to that, often there can be warranties about status of customers and relationships, contracts being assigned over. We've seen examples where uh, in an asset sale, certain representations were made about customers being secured, and certain representations were made about the financial of the business, and there was given a long settlement. Sometimes those customers frittered away. The financials were not exactly as they were at the date of signing the contract, and between that period there was a disruption in the business. So then you go back to the warranties and you have to examine, okay, was there a warranty made about future performance? Was there a warranty made about the financial at the time of the business? So again, I think Mitchell will expand upon this on the drafting to contracts. Um, some other warranties that are generally sought are financial and regulatory. Any valuations are accurate, liabilities to be fully disclosed, compliance with law, any pending action. All of this essentially designed to ensure that the purchasers um, have done have reviewed the business in complete detail. The vendor has turned their mind to each warranty that they're offering, and the vendors are assured that they would be able to comply with it. And if there is that non-compliance, opening up that remedial part. I think I might pass this on back to Mitchell to talk to you about how they're effectively drafted so as to ensure that this mechanism is preserved.
Thanks, Mehraaz. That's a really good summary of the sort of types of matters that we see coming up in warranties. And as you can probably see, just working through those examples, you can probably identify some of those where the buyer would be wanting one way and the seller would be wanting things to be put in a slightly different way. And so we'll go through some examples of that now. And I just start off by pointing out there's a couple of areas in contracts that we look at when we're either reviewing a contract or drafting them. And that's obviously the warranties themselves. So it's really important to look at how are they defined, how are they put, what's the scope of the warranties, does it cover 15 different matters that we've sort of run through some examples of, or is it a short list of maybe 5 or 6 really essential ones, if the seller can get away with that. So the warranties themselves are really important. They're often contained in a separate schedule at the end of the contract, particularly if they're lengthy. But also, we've got to look at the conditions and the terms in the main body of the contract that talk about the warranties. It's one thing to have a very nice list of warranties and all the information that in insurances that the seller is giving to the buyer. But what does that mean if it's breached? What does it mean if something is said to be true and it's not? What can the buyer do about it? And are there any restrictions on what they can do about it? So those sorts of clauses about, I guess you could say, the operation of the warranties, they'll usually live in the main body of the contract, and they're really important as well. And I think it's important too that if you're a buyer, you're receiving a proposed contract that has warranties, don't just take it as a given that, oh, well, there's a warranty section. It looks pretty detailed. I'll tick the box because there's warranties that'll protect me. As we'll see as we're working through the examples, there's different ways of skinning the cat, so to speak, and the devil is in the detail. So do review them carefully. Don't just take them as a given that just because there are warranties, they'll be drafted in a way that's in your favour. So starting off from the seller's perspective, usually the convention with contracts, particularly sale contracts, but any sort of contract for the provision of goods or services, the convention is that the seller sets the terms. So the seller or the provider of the services or the goods will usually put forward their terms for their sale. If you want to buy from me, these are the terms on which I'm offering. And so usually contracts are drafted initially from the seller's perspective. So it's really important to use clear and precise language and define terms to avoid ambiguity. These are pretty good general tips for contracts. It gets very difficult sometimes to enforce contracts where the meaning is a bit vague. It's open for interpretation. Person one thought it meant this and person two on the other side of the fence thought it meant something different. So warranties in particular are an area I think where it's really important to pin things down. So do that. Don't just take for granted that the other person that you're dealing with will have the same understanding of what is meant by a particular term or name of an asset or something like that. Including defined time periods is a good idea if you're the seller. So try not to leave things open-ended as much as you can. So if there's a warranty about the accuracy of the books and accounts of the company, that's in the last 3 accounting periods, for example. We're not going back 5, 6, 7 years or beyond. We'll be happy to commit that for the last 3 years, it's accurate. But if something comes up out of the woodwork from beyond that, you can't get us on that. Qualifiers about the extent of knowledge. So this is drilling down a little bit deeper in terms of to what standard of knowledge is the seller being held to, and that's a question of degree as well. So are they to have actual knowledge? So for example, to the seller's knowledge, the books and accounts are accurate in the last 3 accounting periods, or constructive knowledge. So that's a little bit removed again. So to the seller's knowledge after reasonable inquiry, i.e., if the seller may not have direct knowledge, but if they asked the right questions and looked into it to a reasonable level, the books and accounts are accurate, or best knowledge, so to the seller's knowledge and belief. So to my understanding, they're okay, but I'm not saying that absolutely 100% it's accurate. So that there can be nuances in that kind of wording. And there can be other types of qualifiers as well. So you might say in the ordinary course of the business or the operations of the company, X, Y, and Z are so, or except for liabilities not exceeding $500,000, there are no known liabilities for employee entitlements or something like that. So you can put these kind of parameters around the warranties. And it may be that you might have sought to put no warranties in about particular things. The buyer might come back wanting warranties put in. So as a compromise, you might agree to put those types of matters into your warranties, but with some parameters and limitations around them like this. And then we get into the contract terms and conditions that relate to how the warranties work, which I was mentioning before. So some of the things that we would look at when we're drafting or reviewing a contract is how long will the warranties remain enforceable for? Is it just up until the completion of the transaction, or will there be some ongoing time period where the buyer has the benefit of those warranties? We'll talk about that shortly. What if things change? So Mehraaz touched on this with an example of a client we had where there was significant change from contract signing as the settlement date approached. So a way of addressing that, if you were the buyer, is that you might put in some wording so that the seller is saying that the warranties are true as at the date of signing the contract, and those statements and representations will remain accurate and truthful at the completion date as well. And other exceptions. So there's an example we've put in there, so that the seller warrants and represents the buyer that the warranties are true and correct, except as may have been disclosed to the buyer. So there might be something that was a red hot issue. The seller's been upfront about it, told the buyer about it, but then there was a general warrant, maybe it's to do with entitlements of a particular employee, and then in the general wording of the warranty, there's something that says there's no employee entitlement issues whatsoever. So that would be an example where the seller could say, well, you can't get me on that. I told you about that particular issue. I disclosed that to you before signing the contract, regardless of the general warranty that was there. There might be limitations about the effect of the breach. So, okay, maybe there was a breach of the warranty, but it didn't have a significant impact on you or any impact on you, perhaps. So you can't use that breach as a way of getting out of the contract or just seeking some kind of damages for the sake of it. Yes, slap on the wrist for breaching the warranty, but it didn't impact you in the end. And disclosure again, so that there could be a separate schedule that actually discloses certain things to carve them out so that if they're not being discovered by the purchaser later. So I raised the question of should warranties continue beyond the life of the contract. So from a buyer's perspective, you would say yes, particularly I think if it was a sale of shares or units and you're acquiring the entity or a stake or share in the entity, there may be some kind of things that you will only be able to discover once you're in there. And that only come to light once you've got your feet under the desk and maybe have more access to information and records and that kind of thing, or something. 3 months later, a notice comes out of the blue from ASIC or the ATO. So it would be reasonable from the buyer's perspective to seek that it continues after completion. But in saying that, there should be some limit on that, and the seller would usually want there to be a cap, so maybe it's 12 months or something like that. Enough of a period where you can say, okay, well, okay, fair enough, you need to get in there, but a year is long enough to get your head around things. And if you can't find anything, if nothing comes to light within a year, well, then there's no more protection after that. This isn't going to hang around over my head forever. Are there any carve-outs? So there might be things like the disclosure of certain things that I mentioned before. And if there is a breach, do we rush straight into damages and lawyers at 50 paces, or should the seller have an opportunity to rectify it? Maybe that would be appropriate and contain and limit, or perhaps even avoid any negative fallout for the buyer as a result of that issue that's come about. That would be fair from the seller's point of view. Of course, depending on what the issue is, there may not be an opportunity, anything that can be done by the seller to rectify it, but sometimes there will be. And then the final topic is about enforcing warranties. So we've got our contract. It's nice and clear about what the warranties are and how they operate. But there are different things that can be included about what a buyer can do if they believe there's been a false representation or something comes to light that wasn't disclosed. So the contract term should specify what those rights are. Is there a right of termination? That's not going to be helpful if the transaction settled 3 months ago. The horse is bolted there, then you'd be looking at making sure there's an entitlement to damages. Even if the issue is discovered during the contract period, it may not necessarily be a given that will entitle the buyer to terminate and walk away. It might depend on the nature of the issue. It may be that some warranties are flagged as potentially being serious enough that if they are breached, there's a right of termination, but there could be other ones that are marked as being more minor, and they would just be things that could be rectified. They don't necessarily allow the buyer to walk away. Does the buyer have any obligations? We've been talking a lot about the seller and their obligations to the buyer and the information that they're giving to the buyer. But what does the buyer have to do? For example, maybe they need to notify the seller within a specific period of time. They can't just discover something and then sit on it for 4 months and then decide they'll do something about it. Maybe they need to let the seller know within a very short period of time, particularly if there's an opportunity for the seller to rectify it and try to contain the fallout and the potential harm from that breach. And in doing so, the buyer should be required to give some sufficient level of detail about why they think there has been a breach. What is the issue that's come to light? Sometimes that will be very clear. Sometimes it might be a bit more ambiguous. There might even be room for argument and dispute about whether that it really is an issue, or if it is an issue, has it resulted in a breach of a warranty? So the buyer should be required to put some level of detail to the seller if they think there's an issue, and before going off to court or something like that. And then from the seller's point of view, we touched on this a little bit before, but there's opportunities to put some time limits and other caps around the potential liability that you might face if there has been a breach and maybe the buyer is entitled to damages. There has been some financial loss for the buyer. Well, maybe there's a time period where that sort of claim can be brought, 12 months, as an example I mentioned earlier. But you can also have a cap on the damages. So it'd be quite common to see a seller saying that my liability to you, if there has been a breach of a warranty, will be X dollars, $100,000 or something like that. Or perhaps the value of the fees that have been paid by the buyer or by the customer, or the value of the sale price is the upper limit of the liability. There's different ways of doing that, and partly it depends on the value of the contract as well. If it's a relatively, let's say, small contract, let's say someone's spending $100,000 to buy half of a company, the potential liability and exposure to them might potentially be far in excess of $100,000. But if it was a $10 million transaction, it might be a lot less likely that it would ever get anywhere near that. So that's another area where it's important to look at the specifics of the particular transaction you're in and the contract that you're looking at. A buyer, of course, would want no cap at all, and if you can get that, then very good. If the buyer identifies or suspects a breach, I mentioned there may be an obligation in the contract for them to notify the seller, but if you are the buyer, there are other things you should do. So make sure you've got relevant records and documents. Don't let things go missing, or make sure you've got the paper trail there to show what the issue is and how it came to light. Try to quantify the loss or damage. So just because there has been a breach or an issue doesn't necessarily mean that you can go and get damages if it hasn't had an impact on you, or if it's hard to quantify what that is. There might be some debate about what the extent of the loss is and what the harm is, but it's important to start thinking about that. Okay, I'm not happy that this has come to light, but what's my loss? So look at that. Act promptly, don't sit on it. As I said before, the sooner you get things going with this, the better. It could potentially be a drawn out dispute with the seller. So you want to act quick promptly from that point of view, but also to try to contain the losses and the damages that you're suffering if that's the case. And check the contract terms. Don't rush into doing anything without going back to the contract and seeing, is there a dispute resolution procedure? What jurisdiction should that be filed in and run in? Should there be mediation first? Should there be other steps before that? The warranties clause itself might have a process for what the buyer needs to do if they suspect there's been a breach of warranty before we even get to a dispute resolution process. So do check the contract before doing anything to make sure you're on the right path. So I'll finish off with some examples, and we put together a very general set of warranties clause that would live in the main body of the contract that has some examples of the sorts of things we've mentioned today. You'll see my little disclaimer there. This is not an exhaustive list of everything. Sometimes these clauses are very long, sometimes they're very brief, but this one is designed to just give a bit of everything. Or a flavour of everything, I should say. So we might start off by saying the seller warrants and represents to the buyer that each of the statements in the warranties in Schedule 1 are true, accurate and not misleading as at the date of this agreement, and will be true, accurate and not misleading as at completion. So maybe they're being generous putting that in, or maybe the buyer negotiated to put that in. But then we've got some exceptions. So except as specifically disclosed in Schedule 2 with detail, or except as disclosed in the financial statements and notes, or except as would not reasonably be expected to have a material adverse effect. And just add a comment too that you'll see I've used capital letters on material adverse effect. Often that's a defined term. So and you could look at how is that going to be defined in this sort of transaction, in this sort of business, or with these types of assets. What would be a really significant financial impact if something went wrong? And that could be defined and scoped in the agreement. I should say, as we're running through this example, it may be that some contracts might have one or two or three or none of these. We just put them in as examples. How long do the warranties survive for? So in this example, the warranties survive completion and the performance of all obligations under the agreement, and they'll remain in force and effect for up to 24 months from the completion, or if it's relating to tax matters, 7 years from completion. So there's some examples there of putting some time periods around things if they are going to go beyond the completion date. What can the buyer do? So if a warranty becomes untrue, inaccurate or misleading, the buyer may, subject to limitations we'll look at in the next slide, claim damages from the seller. They might be able to set off amounts owing to the seller So there might be payments over time, the vendor finance that the buyer has to pay to the seller, and maybe they could be reduced to offset the loss. Maybe the buyer can seek specific performance or other relief. So there might be things that where money can't sort of set things right, the buyer needs the seller to actually do something to set it right. And some limitations. So the seller's total aggregate liability for claims arising from breach of warranties. So if there were 5 breaches, for example, we're talking about the total liability for all of those breaches. So there might be an overall cap, so the total amount paid by the buyer under the agreement. There might be an individual claim threshold. So any individual claim can't be brought unless it's for at least $10,000. So if we're trying to rule out any little trivial stuff, if you find little things that come to light, you just got to put up with that. You can't come and chasing after me unless it's significant, because then we don't want to be having to get incurring legal costs and the time and inconvenience of dealing with small fry things. And an aggregate basket. So the seller has no liability unless the total amount exceeds $100,000 or something like that. And there can be carve-outs from the caps. So it may be that the vendor, the seller does not have the benefit of those liability caps if there's been fraud. If there's been breaches of assurances and warranties about ownership and their right to sell the assets or the shares. Warranties about the seller's power and authority to enter into and perform the contract, and that goes to the buyer as well. Particularly, we see these sorts of warranties where there's a trust involved. It's really important to make sure that the trust deed gives the trustee the power to enter into this type of transaction. And if there was a breach of that and that turned out not to be true, then that could be quite serious and have significant consequences. And criminal conduct, if anything came to light, maybe there's no cap on the seller's liability if something serious of that nature came to light. And finally, some more obligations on what the buyer must do. So if they think there's been a breach, a notice of claim must specify the warranty that the buyer thinks has been breached, reasonable details of why they think that's been breached, their estimate of the amount of the claim and their loss, and copies of documents to support that, so that the seller can have a genuine opportunity to consider the claim and respond to it. And finally, the requirement in this clause for the buyer to give notice to the seller of any warranty claim within 30 days of becoming aware, not sitting on it for 3 or 4 months. And that time period might depend on the potential breaches that could exist in that type of transaction. So I hope that's helpful, just to give you a little bit of a sense of the way these sorts of things could play out when they're put in black and white on the page. But as you can see as well, there's probably a lot of room for movement and different nuances and flavors to these clauses depending on which side of the transaction you're on. So that brings us to the end of the content. We do have a couple of minutes for questions. So if you do have any questions, feel free to put those in the Q&A box. We don't have any at the moment, so I'll just flag the resources page on our website where the recording for this webinar will go up. We're also regularly publishing articles and alerts on different things, cases that are coming to light, things we've been involved with, and changes in the law, and our legal guides are there as well. For a recent one we published on directors' duties and obligations, so that would be useful for many of you, I'm sure, and that's available to download, and we can also send out hard copies if that's wanted as well. Our next webinar is coming up in August from our property lawyers on lifestyle villages and aged care homes. They're a very complex area when it comes to the contracts, and there have been some recent decisions about interpreting those clauses and those contracts in terms of payments and things like that. So if that's of interest, do pencil that in, and we'll circulate more details of that shortly. And finally, a quick plug, if you'll forgive me, on David Sharrock's book, Fighting for Enterprise Success Through the Eye of the Tiger. It's a really great guide and workbook on different things relevant to successful business or enterprise, or including not-for-profits, of course, and from a systems-based point of view. We've got lots of examples in there from our business that have been useful for us to spark ideas, and lots of stories and anecdotes from David as well. So check that out if that's of interest. Finally, thank you again for joining us. If you do have any questions, or if any of this has sparked any concerns or queries for you, feel free to get in touch with Mehraaz or myself. We're always happy to have a chat or respond to an email. In the meantime, we'll leave things there, and I hope you enjoy the rest of your day. Thank you.